So at the moment, the way it works for a person who's going to be subject to it is that they arrive in Australia, they make a protection claim. Ordinarily that protection claim will be assessed first to see whether they are a refugee or a person entitled to complementary protection. At that point, as happened with my client, they were released from immigration detention into the community, engaged with the community in a perfectly peaceful way, and then after a period of weeks, they got notice from the department that in fact, having been found to be a refugee, ASIO had made a negative assessment so that they were taken back into detention for more than a year after that, while the assessment was supposedly reviewed within the government. That's the way it works at the moment, with one relatively recent caveat. That is, on an annual basis, a former federal court judge is going to be reviewing those ASIO assessments to see whether they are still up to date. In theory, that review will result in some people being released when the annual assessment says they're no longer a risk to national security. So there have been a series of challenges to the ASIO scheme as it is. The most notable of those challenges was a case called M47, which was heard in the High Court. The High Court in that case decided that the regulations were invalid, that the Act required that the Minister for Immigration make a decision about whether a person got a visa or not, rather than the Minister, as it were, outsourcing to ASIO part of that decision. The invalidity of the regulations, however, didn't mean that the scheme fell away, it just meant it needed to be reshaped, and that reshaping is now in the form of the annual review, the assessment by the Honourable Margaret Stone, who looks at the assessments on an annual basis and notionally reviews them to see what it is that the person's risk assessment is at that time. The thing to note is that there are more challenges afoot. There was a very recent challenge called S38, also in the High Court. That challenge fell away when the assessment was reviewed on the eve of the court case being heard, so that no longer are those people detained, and now, as I understand it, they're on the path to getting a visa. There's another challenge which is on the horizon, and that challenge is called M47. As it happens, M47 is the same person as M46. That's coming up in the High Court, and that will be seeking to challenge the new regime to see whether it is valid, lawful, and whether the scheme as it's currently in place is one that the High Court will sign off on. The biggest issue for legal practitioners is that we're working in a vacuum of information, a vacuum of sources, and a vacuum of process. And from a lawyer's point of view, all of those things are thoroughly uncomfortable and probably run against the grain of the basic notion of the rule of law that we all rely upon in our day-to-day living. In a sense, I think the ASIO issue is one that is symbolic of more fundamental concerns. The 50 people odd who are currently detained, of course, are a concern to many people in the community, but on a systemic institutional level, what it represents is something deeper, something that we should all probably be a lot more concerned about in terms of what it represents. There's a case decided in 2002 in America where a judge pointedly said, democracy dies behind closed doors. And I think we might be seeing a bit going on behind closed doors that make us, or should make us, worried about the state of our democracy.